Yes.
My Lords, I, Mr. Edinburgh, and my learned junior, Miss Neve Harret, appear for the appellant, which is Oatly. My learned friend, Mr. Tom Moody Stewart, of His Majesty's Council, appears for the respondent, Dairy UK. I trust you all have bundles, either soft or hard copies, as is appropriate.
We will all be working from soft copies.
Fine. In which case, for those who are working behind me from both, I will give a tab number and a page number, which should allow everybody to get to the hard copy or the soft copy.
Yes, as long as you give us the electronic number.
Yes, the electronic number.
Thank you.
I hope it corresponds, he says. The way in which I was going to deal with this, if I may, was very briefly open the case in brief and then delve in more detail in 5 parts: the procedural history, the legislative framework, the context of the legislation, and then ground 1 and then ground 2. Very briefly, we say the case is quite simple. Without trying to steal my learned friend's thunder, the way in which Dairy, the respondent, has put their case is that any use of the word milk is bad, because any use is as a designation and therefore prohibited by Part 3.5 of the relevant regulation if it's not used in respect of milk products. This leads to an obvious difficulty that the Court of Appeal alighted upon, namely that the phrase milk-free is also bad. And the way in which Dairy endeavoured to get around that is by saying that the Court of Appeal was wrong with respect to a certain part of their judgment, namely that the proviso to Part 3.5 is wide enough to include terms such as milk-free. This requires them to disagree with the Court of Appeal and also for them to hold that milk-free falls within the second limb of that proviso. Oatly, the appellant, says the matter is much simpler. We say that what you do is you look at the 3-word phrase post-milk generation and understand it as a whole in context. You don't salami slice the whole into disjointed parts. Rather, each part synergically interacts with the other words in the phrase and all contribute to the meaning of the phrase. And you then look at the meaning of the phrase in context. We say that the 3-word phrase post-milk generation refers to an attribute of the target audience, namely those people who have moved beyond drinking milk for whatever reason, and therefore, by necessary implication, any product that is marked with the trademark post-milk generation describes an essential characteristic of those goods, namely that it does not contain milk. We say that the phrase post-milk generation is not and cannot be the name of any given product, as that characteristic applies to many things. And therefore, because it is not the name of any given product, it is not a designation, because it's not the name of anything in particular. And if it's not a designation, then it doesn't fall within the scope of the prohibition of Part 3.5, and also it's not caught by the sweep-up term, sweep-up clause in point 6, which is a long-stop safeguard, because we say the phrase post-milk generation is not deceptive in that it doesn't suggest any dairy connotation. We have a fallback position, and that is if you were to hold, contrary to my primary position, that post-milk generation is a designation, then we say it falls within the second limb of the proviso to point 5, because it clearly describes a characteristic of any good so marked, namely, it has no milk. And with this analysis, we don't have the problem that faced the Court of Appeal because the phrase milk-free, we also say, is not a designation. And if it's not a designation, then it's not caught by any prohibition. So that's simple. But if you were to hold that milk-free also is a designation, then it falls within the second limb of the proviso because it describes an essential characteristic of the products, namely no milk, just as the phrase post-milk generation is descriptive of an essential characteristic.
So you say milk-free is not a designation, but even if it were, it would fall within the second limb of the proviso?
Yes, my Lord, correct on both points.
And it's common ground that if it were, milk-free would fall within the second limb of the proviso. It's now common ground.
Yes, there was a complicated and convoluted debate in front of the Court of Appeal.
Yes.
Probably best not to explore in some detail. But yes, I mean, this is in some ways the reason why the whole case has arisen, is because of this problem of milk-free. And we say, especially when you look at the decision in the Court of High Court, that Mr. Justice Richard Smith agrees with us that if you look at milk-free and that's good, then post-milk generation is good as well. But I'll come to that in a moment. With respect to the procedural history, this can be dealt with quite simply. The matter is a trademark matter, even though in some senses it doesn't deal with much of trademark law, because it's mainly EU law with respect to the milk regulations. But it is important in this context. The phrase post-milk generation was sought to be registered as a United Kingdom trademark, and it was successfully registered as a UK trademark. And that means, as a necessary consequence, that it is not descriptive of any type of product. It is not the name of any product. That follows automatically from the acceptance of the trademark post-milk generation. And that must be presumed in favour of Oatly. Now,
why must it be presumed?
Because there's been no attack on the validity. So the validity...
So you say you can't come along and rely on the EU structure without also attacking it as a trademark? There's 2 points there. The point I'm trying to draw out is that because it's been accepted as a UK trademark, it must be accepted that it is not descriptive of goods. Because it's the validity of the UK trademark has never been questioned on that ground. And under Section 72 of the Trademarks Act 1994, unless you put validity in issue, the validity of the mark is assumed.
But I thought this whole case was about the validity of the trademark.
It is, but it's on a separate ground.
Yes, quite.
It's not on the descriptiveness point.
But how does that fit with your backup position that the second limb of the proviso applies?
Because we say that it's not descriptive, it's not the name of any goods, but it can still be sufficiently clear to indicate a characteristic of those goods. Now, because the mark was registered, the way in which you need to attack it is by an application for invalidity, and that occurred in the United Kingdom IPO. The attack was predicated upon 2 provisions, the first of which was that it contravened, in essence, the EU milk regulation, and secondly, also that it was deceptive. That's the Section 33B. Now, in the IPO, the application for invalidity succeeded on the ground that it contravened Section 3.4, namely it was contrary to the EU regulations, but it failed with respect to the Section 3.3b. So therefore there's a finding of fact that hasn't been challenged anywhere, that the mark is not deceptive. The decision was appealed successfully by Oatly to the High Court, and then it was appealed again the other way around by dairy to the Court of Appeal, and dairy was successful there. Then the matter has now been appealed to your Lordship's Court, and unqualified permission was granted for this appeal. I was now going to take you, if I may, to the legislative framework. And this may be found behind tab 32, starting at page 468. So this is the regulation that is central to this case, Regulation 1308 of 2013, so I'll refer to it as the 2013 regulation, establishing a common organisation of the markets in agricultural products, and it repeals certain other earlier pieces of legislation, in particular Regulation 1234 of 2007. If you turn to page 471, you come to the relevant article, which is Article 78, definitions, designations and sales descriptions for certain sectors and products. And if you look at 78.1c, you'll see that it refers to the milk and milk products intended for human consumption. And then 78.2, the definitions, designations and sales descriptions provided for in Annex 7 may be used in the Union only for marketing of a product which conforms to the corresponding requirements laid down in that annex. You then need to go to Annex 7, and that may be found to commence at page 475. And we need to look at the first part, which says definition, designations and sales description of products referred to in Article 78. And it says, for the purposes of this annex, the sales description means the name under which a foodstuff is sold within the meaning of Article 5.1 of a certain directive, or the name of the food within the meaning of Article 17 of a different regulation. So you have there a definition of sales description being the name under which foodstuff is sold. Now, this annex deals with various food sectors, but the milk sector is part 3, and that may be found at page 483, and it's headed Milk and Milk Products. Now, over the next page and a half, within part 3, you have 6 points, and I need to take you briefly through those. So part 3.1, milk means exclusively the normal mammalian secretion obtained from one or more milkings without either addition thereto or extraction therefrom. And if you look at 1b, it says in association with a word, however the term milk may be used, 1b, in association with a word or words to designate the type, grade, origin and or intended use of such milk. I'm drawing your attention to that because it uses the verb designate. Point 2 deals with milk products. And in point 2, you'll see that neither the verb to designate nor the noun designation is used. If you turn the page to 483, you come to point 2a, where it's saying the following should be reserved exclusively for milk products. A, following names used at all stages of marketing. Now that phrase, names used at all stages of marketing, as I will show you in a moment, used to be the definition for designation. And we say that it actually is still the meaning of the term designation. And then if you get to point 2b, it talks about the names within the meanings of Article 5 of the relevant directive or Article 17 of the relevant regulation. I'll come to those in a minute. But what's pertinent with respect to 2A and B is it's referring to names of products. So a descriptive term that is the name of something, an entirely generic usage. Point 3 reads the term milk and the designations used for milk products. So therefore, that when it says designations used for milk products, that must be referring back to point 2, which is all about milk products. But you've already seen that in point 2, it never uses the term designations. Rather, it's using the term name. Point 4 is not relevant for present purposes. It's basically about milk that comes from other mammals. Then we come to point 5, which is the central issue in this case. The designations referred to in points 1, 2, and 3 may not be used for any product other than those referred to in that point. Now, to reiterate, in point 2, the term designation is not used, but point 5 refers back to the designations referred to in point 2 inter alia. So therefore, that must be referring back to the names in 2A and 2B. And then in point 5, we get this proviso. However, this provision shall not apply to the designation of products, the exact nature of which is clear from traditional usage, and or when the designations are clearly used to describe a characteristic quality of the product. And then point 6, we say, is the long stop safeguard, which basically prevents anything that wrongly claims, implies, or suggests that the product is a dairy product. So that's the framework in which this case arises. Now,
So 6 is the deceptive safeguard, in effect.
yes, it's basically, it covers absolutely everything that's not covered before. And so, for example, can you see that it uses words like no label, commercial document, publicity material, or any form of advertising? That's pretty general wording. So we say it would include something like the use of a cow to falsely say that the product to which the image of the cow has been affixed implies that it's a dairy product. It's a safety net.
And how about the last paragraph on page 484, which refers to designation, milk, all the designations referred to in the second subparagraph of points 2?
Yes, that's actually not relevant, thankfully, for this present case, because that's dealing with respect to raw materials and things that may be in milk products. I was then going to, if I may, place this legislation in context. It's common ground.
I think my Lord's point might have been that
milk is assumed to be a designation.
Exactly.
Sorry.
Whether or not point 6 is, the second paragraph of point 6 is functionally relevant, I think the point which was my Lord was trying to make to you is that it could be said that whoever drafted this was operating on the basis that milk was always a designation.
Milk is a designation if you're looking at the term milk by itself. I accept that. But my point is that you must look at the way in which the term milk is used, and it may be used in a way that is not a designation. And I'll come to this because in the Alpro case, it makes that point absolutely clear that not all uses of the word milk amount to a designation. But milk by itself is a designation. It's common ground between the parties that this regulation still applies for your lordships, assimilated law. The details of all that are set out in the statements of case. The first point under this is I'd like to look at the history, because this regulation did not come out of nothing. It has a very long history. Very briefly, it started life in a regulation dated 1987, which for your note starts at page 604 in the bundle. It then was reformulated in a regulation dated 2007, which may be found to start at page 624 of the bundle, and then came into the 2013 form, which we're looking at here. And it is relevant in my submission that all three of those pieces of legislation have a very similar structure and wording. And what we have done in Annex 1 to our statement of case that may be found commencing at page 52 behind tab 4 of the bundle, is we've put in tabular form the relevant parts of those three pieces of legislation, and we've highlighted in yellow the exact wording, in green similar wording, and we've used blue where we think something is particularly important. And on page 52, you can see that the left-hand column are the extracts from the 87 regulation, the middle column from the 2007 regulation, and the right-hand column, the extracts from the 2013. So that's our regulation. And moving to page 54, we get to the guts of what I've just shown you, namely in the right-hand column, Annex 7, which in the 2000 regulation was Annex 12. And can you see how much of that material on that page, the next page, and running through to page 56, which are the points that I've just drawn to the attention of this court, is in yellow? It is exactly the same wording. The structure is basically the same. They've renumbered the paragraphs, but the structure is the same. So the same thing follows in the same order. Reverting to page 54, which is the beginning of this relevant part, what I need to draw your attention to is that in the 87 regulation, can you see that under Article 1(2) of that regulation, 2b, it defines designation shall mean the name used at all stages of marketing. So that's top of the page of 54 on the left-hand side, Article 1(2)b. Then if you look at the middle column in the 2007 regulation, Part 1 definitions, it has exactly the same definition. Designation means the name used at all stages of marketing. Now, in the 2013 regulation, that definition is not there. And that was one of the grounds upon which the Court of Appeal said, well, therefore it's not there, therefore it means something different. Well, in my submission, that is wrong. First point really here is that for 26 years, the term designation had been defined in the 1987 and then the 2007 regulations to mean exactly the same thing. And if all of a sudden in 2013 you want the term designation to mean something different from that which it has been defined to mean for the last 26 years, it's incumbent upon the legislator to make that difference in meaning clear. There is no such clear, contrary meaning put forward. Rather, we say it's assumed that the meaning that's been there for 26 years carries on. And partly in support of that, if you go to page 55...
Just before we do,
yes.
Can you just help me with your colour scheme? I understand what exact wording means. Oh, sorry, I'm actually gone there. I'm just puzzled with what emphasis means.
Well, because you'll see, if we're on page 54,
Yep.
we emphasise the word designation.
Yes, it's really just focusing on what you see as the key,
Yes.
the key word.
Cases about designation.
Yes.
I mean, it could have been just yellow.
Okay. All right.
Or maybe it should have been yellow and underlined or something.
Well, it's not quite yellow because it hasn't carried through to 2013. Yellow, it'd only be yellow if it went through all three, wouldn't it?
Yes.
But it's gone in 2013, so because you've got the same in yellow. Anyway, okay, thank you.
I was moving to page 55.
Yeah.
And if you look at the middle column, this is the 2007 regulation. And this is using that number in Part 2.2a. It says at the top of page 55, the following should be reserved exclusively for milk products. A, the following designations. And then if you move to the right-hand column, you can see the following should be reserved exclusively for milk products. A, the following names used at all stages of marketing. And so therefore, the phrase names used at all stages of marketing has been used in exactly the place that designations was used in the 2007 regulation. And we say that therefore the term designation hasn't changed its meaning. And if you go to the next page, 56, this is where you can see in the right-hand column under point 5, the designations referred to in points 1, 2 and 3 may not be used for any product other than those referred to in that point. the term designation isn't used in point 2 in the 2013 regulation, but the phrase which has been defined as designations for the previous 26 years is used in 2A, the names used at all stages of marketing. So we say that from the structure of the 1987, the 2007 and 2013 regulations, you can see that the term designations has not changed its meaning. And we get further comfort for that conclusion because there's only 2 cases, you'll be pleased to know, that have any bearing upon this case. And the first of which is Tofu Town, which may be found sorry, my bundle has now fallen apart. May be found starting at page 1062. This is a case that went before the Court of Justice with respect to certain plant-based products like tofu butter and things like that. But for present purposes, what is relevant is paragraph 9, which is on page 1065, where it's talking about the history, and it says, in brief, the provisions of the 2007 and the 1987 regulations have been reproduced without making substantive changes in the 2013 regulation. We say that supports my submission that the definition of the term designations has not changed. Because if it had changed, that change needed to be pointed out expressly in 2013, and the Court of Justice in Tofu Town, which is a decision in 2017, could not have said that which it did say in paragraph 9, that the 2013 regulation reproduced without substantive change the earlier 2 regulations. We say, with respect to the context of the legislation, it's also pertinent to look at the purpose of that legislation. And that may be seen most clearly in the 2007.
Why do we go to the 2007 regulations for the purpose? Why not go to the 2013 regulations?
Because, my Lord, in the 2013, there isn't a clear statement as there is in the 2007. So that's why I was going there. But then I was going to support it by showing that the case law in 2019 has the same sort of purpose. So that's why I can't show you the same wording in 2013. So the 2007 regulation, which may be found behind tab 30, but starting at page 453, sorry, it starts at page 451, but 453 is it's 452, I'm terribly sorry.
Yeah, 453 doesn't help much.
It's recital 51. And it's about halfway down that paragraph on the right-hand column, where it talks about the aim at protecting the consumer and at establishing conditions of competition between milk products and competing products. So there seem to be two purposes. One is protecting the consumer, and the second is establishing competition between milk products and competing products. And then deal with this exact point with respect to the fact that it's not in the 2013 regulation. We can pick this up, though, in the second relevant case, which is the Alpro case, which starts at page 1073 and is behind tab 71. This is a 2019 decision. This decision is a decision of the Supreme Court of the Netherlands on appeal from their Court of Appeal. And on page 1083, in the second paragraph on that page, when assessing whether the use of a reserved name under point 3.5 or 3.6 should be prohibited, a great deal of weight is given to the objective of the regulation.
Sorry, where are you?
I'm terribly sorry, my lord. 1083.
83.
Oh,
Thank you.
83.
Just the paragraph 3.2.7, the last subpara.
My lord is absolutely correct.
Thank you.
It's the second paragraph on 1083. A great deal of weight is given to the objective of the regulation, avoiding the suggestions that it concerns a dairy product, open parentheses, in order to prevent confusion among consumers and thus preventing unfair competition. So that parenthetic remark in this 2019 case mirrors that which was in recital 51 in the 2007 regulation. So we say that the same purpose was carried through to the 2013 regulation. And we say that's entirely consistent with the fact that the 1987, the 2007, the 2013 regulation basically did the same thing in the same way. They're just restatements, consolidations, simplifications. And there's no change in anything. So the wording has remained the same, the purpose has remained the same.
I was wondering, could you assist me? Is this an official translation, or what's...
This is, no, it's not an official translation, it's a certified translation.
Certified by whom?
By the translator. You'll find that on page 1091.
And a translator employed by whom?
By the appellant, Oatly. But there's no contrary certified translation. Dairy dispute certain points of the translation, but have not put in their own certified translation. And just to be absolutely clear, in the permission to appeal application, it was an unofficial translation that was used and quoted, because at that stage we didn't have a certified translation, but this is, in your bundle now, the certified one. Lord, as I didn't answer your first question fully, does that answer?
Thank you very much indeed.
Right.
It's certified by somebody who's a professional translator.
Yes, I mean, it's all we can do.
Yeah.
I mean, it's actually an interesting point, because you'll see that Tofu Town, which is the English version of a Court of Justice case, actually differs when it quotes the regulation from the English form of the regulation. And so there are slight differences in wording, but we say in this case that does not matter, because you can still take the central thrust of the judgments. Now, my last point under the context of the legislation is a very short point, and that is, if you look at the various preparatory materials for these EU pieces of legislation, the long and short of it is not much turns on it. It basically doesn't give any indication that there's going to be any change, but there's no real detail. The material's there because one could anticipate you'd ask about it.
You mean there are no bullseyes?
To use my learned friend's phrase, yes. But it's necessary
Well, I don't sure it's his phrase. I'm sure somebody got their.
Oh, sorry, yes. It was actually Lord Justice Jacob.
It was Lord Justice Jacob,
Yes.
I remember that, yes.
Sorry, but my learned friend quoted Lord Justice Jacob from
Yeah,
the Nova case.
sure.
Sorry, that was an abbreviation of that long point. But it was included because otherwise you'd ask about it, basically. So all of that, we say, goes to a simple point. The history shows that the wording and the structure of the legislation hasn't changed for decades. We say the purpose is clearly the same, as supported by the 2007 recital and the Alpro Supreme Court decision. The structure's the same, so therefore the word designation means the same. And so when the Court of Appeal says, well, just because there's no definition of designation in the 2013 regulation, that means it has changed, we say, no, that's wrong. If there was supposed to be a change, it was incumbent upon the legislation to point out that change. They didn't do that, therefore there's no change. That then gets me to my fourth point overall, which is the ground of appeal, the first ground of appeal, where we now need to focus down upon the meaning of the term designation.
I suppose your point about it not being pointed out gets resonance if someone is doing something under the 2007 regime that isn't prohibited and just goes on doing it when 2013 comes into force. You say it would need to be pointed out if the effect of the change is to make that prohibited.
Yes, and my Lord, I was going to deal with that later because Amendment 171 touches upon that. It was an attempt to change things.
I know that.
And we say the only purpose of trying to change something is if you, to put forward the amendment if you want to change something. The amendment failed, and therefore we say there was no change. And we do say that's a bullseye. But I'll deal with that when I come to it. So where I was my fourth overall heading, which is now Ground of Appeal 1, and I'm dealing with the term designation. And we say that the term designation hasn't changed its meaning for the reasons I've given, and that the term designation in essence means the name of something, a generic name of something, a descriptive name of something. And you can get support for that. Remember, I was referring to Article 5 of a directive and Article 17 of another regulation. Well, if we can now go to those. The relevant directive may be found behind tab 29, starting at page 449. This is Directive 2000 number 13. And Article 5 may be found on page 450. This, you'll recall, was referred to in the 2013 regulation at point 3.2b, part 3.2b. And Article 5 reads, "The name under which a foodstuff is sold shall be the name provided for it in the community provisions applicable to it, and then it goes on and gives even more detail. But the long and short of all that is it's the name of something. So milk is a generic term for the product milk. It's the name of that product. Likewise butter, likewise lamb. And then in Article 5.2, it says no trademark, brand name or fancy name may be substituted for the name under which the product is sold. Now, we only place light reliance upon that, but the indication there is that you must be using something which is a generic term, not in essence a proprietary term. Now, the regulation to which reference was made in Part 3.2.b may be found behind tab 31, starting at page 466. And on page 467, you get Regulation 17, and that is name of the food. 17.1, the name of the food shall be its legal name. In the absence of such a name, the name of the food shall be its customary name, or if there's no customary name, or the customary name is not used, a descriptive name of the food shall be provided.
This is Article
17.1, page 467, my Lord.
Thank you very much. Yes.
And I've been referring to this regulation and the previous directive because those two were both referred to expressly within the 2013 regulation, Part 3, Point 2. A and B.
Oh,
Sorry,
17,
B.
Yes, I see.
And the reference to that is page 484 of the bundles. Named in the meaning of Article 5 of the directive and Article 17 of the regulation to which I've just drawn your attention. Now, I've already drawn your attention to it, but sales description is defined in the 2013 regulation. You'll find this on page 475 of the bundle as the name under which a foodstuff is sold. And we've had the definition of designation in the 2007 regs, which is the name used at all stages of marketing.
Where do we see? That's designation, yes.
457, my Lord.
Do we see the word sales description used in the earlier regulation?
Just one second. Well, yes, but not quite in the same sort of way, if you see what I mean, in the sense that it is used. If you go to page 459 of the bundle, but this is under a different, this is in spreadable fats. This is part of my learned friend's case. 459, sorry, of
yes.
the bundle.
Oh, yes.
Now, what we say is that you have the name of something. You get that from
Article 5 of the directive and Article 17 of the regulation 1169, you have sales description, which is the name under which a foodstuff is sold.
So can you give me the page number for that definition in 2013?
475.
Thank you.
And designation is the name used at all stages of marketing. So they have slightly different but overlapping meanings. So we've never said that sales description equals designation. Point being is designation is wider, name used at all stages of marketing, whereas the sales description is the name under which a foodstuff is sold, which is a particular point of the marketing operation.
And is that also clarified in Article 5.1 of Directive 2000/13/EC? The definition of sales description means the name under which a foodstuff is sold within the meaning of. And I'm just wondering whether it makes it absolutely clear that it is at the point of sale. That's the distinction you're trying to draw, as opposed to
At all stages.
At all stages. But I was just wondering whether Article 5.1, where we can find Article 5.1 of the directive. It may be irrelevant, but I'd just like to...
No, but what I'm trying to draw is in some sense, a more general point, which is that all these terms are referring to the name of something. They're all descriptive, generic terms.
But in order for designation and description, sale description, not to have the same meaning, you have to limit sale description to the point of sale.
Yeah.
I'm just wondering whether we have Article 5.1 of Directive 2000 in the bundle.
The 2000 directive.
Well,
Yes, we do.
Is that page 450?
That's 450, my lord.
450.
Sorry,
right.
my lord.
I do apologise.
Yeah.
So can I just be clear? Is there a difference in your view between designation and name? You're clearly distinguishing designation from sales description. I understand that, for the reasons that you've just said. Designation seems to be wider because it's dealing with all stages of marketing, whereas sales description seems to be narrower, potentially. But are you saying there's anything different about name as such?
Well, that's a more difficult question, obviously, my lord. But the point being is that both the term sales description and designations are defined by reference to the term, the word name. And so they both focus back on the name of something. Now, whether designation equals names in all stages is a moot point, and I don't need to determine that.
But you did say earlier that it meant a generic or descriptive name.
Yeah, because these three terms are used consistently in that way. And the reason I'm hammering on about this is because that's in flat contradistinction, we say, with the way in which the phrase post-milk generation is used. You cannot use the three-word phrase post-milk generation as the name of something. It's not a naming, it doesn't have a naming functionality. There is no thing out there that is uniquely described as post-milk generation. But the phrase post-milk generation, we say, clearly describes a characteristic of anything so marked, namely, doesn't have milk.
Yes, that's your second limb of the proviso point.
And those
That short paragraph is my case, basically.
But I mean, just coming back to point 5
My lord.
on page 484,
Yes, my lord.
it refers to the designations referred to in points 1, 2 and 3.
Yes.
And milk is one of those designations because it's in point 1.
Yes. 1B. Yes,
Well,
yes, yes.
it's milk means. I mean, milk is obviously referred. It's one of the designations. The other ones are milk products, and then the other ones are all those wonderful things starting with "way" and ending with
Yes.
with Rajenka. No, Rugus piens.
Yes, my lord.
Whatever that means. And so they're all designations when you get to point 5. Is your point that when it says may not be used for any product, do you mean may not be used as the name for any product? Is that where designation has some functional effect in terms of your submission?
Yes.
Because I think the other side is saying it may not be used in any way in relation to any product.
Exactly.
Yes.
I mean, this is where we say context is all important.
I'm just trying to see where
Yeah.
the dispute about what designation means actually has some functional consequence in terms of what we're here arguing about.
Without trying to wrongly summarise my learned friend's position, my understanding is their position is that the 4 letters M-I-L-K cannot be used full stop because it's always a designation. If it's a designation, it falls foul of part 3.5. We say that's simplistic because you must look at the context. Designation that is prohibited is a naming thing, something that names a product. And if what you're considering is not a naming thing, not a designation.
Well, the prohibition is used for any product. You say it means used as the name for any product because designations are names.
Yeah.
They say the words used for any product are used in any way in relation to any product.
Yeah.
That's really, it's what this all.
Yes.
That's what the designation part of this debate comes down to,
Yeah.
isn't it? It's really about what the words used for any product mean in the prohibition.
In the prohibition, yeah.
And do you agree that milk is a designation within point 1, part 3.1?
Yes. But the qualification of that answer is when you're using the term milk by itself in the relevant context, it must be a designation, and so therefore it's a term that can be prohibited. But we say it's inherent within the whole structure of the thing that designation means you're using something as a naming thing. And with respect to the phrase post-milk generation, the term milk isn't serving a naming function. It's part of the phrase post-milk, which is an adjectival phrase which is qualifying the noun designation. And then when understood as a whole, i.e. context, post-milk generation is not using the word milk in a naming function. And post-milk generation is therefore not the name of a foodstuff and is therefore not a designation. And if it's not a
So if we have a drink which has on it post-milk generation drink, what do you say? Is that naming the drink, or what is that?
What we say there is that the three-word phrase post-milk generation is functioning as a trademark, which indicates the trade origin of the product to which it's affixed, and is not naming the product in a descriptive, generic sense. So it could be affixed to a bottle of water or fizzy soda. Or coffee. And it's equally applicable to all of those different things because it's not the name of a particular product.
Well, the only common feature is they're not milk.
I was just about to say that, but you said it for me. Well, a black coffee. So, Café Noir. And see, that's why we say it's simple, because if the use of those four letters, M-I-L-K, in post-milk generation is not functioning as a naming thing, so therefore post-milk generation is not a naming thing, it's not a designation. If it's not a designation, it doesn't fall within Part 3.5. Therefore, it cannot offend Section 3.4 of the Trademarks Act, and therefore it's a perfectly good trademark. And the second point...
And you say that's just the same as if we have a drink which says on it milk-free drink.
My lord, yes.
That's exactly the same.
And I guess
it's not naming the drink as such. You're saying it's defining a characteristic.
Yes.
Or pointing out a characteristic.
It's only characteristic in the sense that it's not milk.
Yes.
Otherwise it could refer to any liquid in the world.
Yes. That's not milk, yes. But I mean, I get support for that from, I was going to take you to this in a moment, the decision in the High Court, Mr. Justice Richard Smith, where he makes that analysis clear. And then, you see, if we were to clear our way past Part 3.5, for it still to be permissible, it must not fall foul of what we say is the long stop provision, which is in point 6. And we say it does not fall foul of point 6 because it doesn't imply or suggest that it's a dairy product. And the support for that is that the mark was found not to be deceptive. My Lords, I was then going to deal with Amendment 171, but very briefly, because we deal with this in length in our statement of case. The simple point is that a proposed amendment was put forward, namely Amendment 171, and for your note you can find this on page 284, which we say would expand the scope of point 5 quite a lot. It didn't pass, and so therefore the scope was not expanded. Therefore we say the scope was not changed. Whether or not this is a bullseye point or not, I'm not going to delve into, because either you think it is or it isn't.
But you say the thinking behind the person, the thinking in the mind of the person who was writing the amendment, which is the bit in italics as I understand it, is that in its original form, this was only a prohibition for using a designation as a name.
Yeah.
I think that's what you're saying.
Yeah, yeah. And it goes wider in the amendment.
Whereas you wouldn't need the amendment if the prohibition on use was any kind of use in relation to the product.
Yeah.
Yeah.
My Lords, if I may, I was then going to take you to the only two pieces of potentially relevant European case law. So the first one is a tofu town, and you'll find this starting at page 1062. In some senses, it's not a particularly helpful case because it's not directly on point. But the reason you've got it is because it's basically the only Court of Justice case that discusses this. But we say that the relevant bits are in paragraph 9, to which I've already taken you to, namely there's been no change in the purpose of the relevant legislation between 1987, 2007 and 2013. And then the only other helpful bit, or potentially helpful bit, may be found in paragraph 33, page 1069. And this is where it's quoting the relevant legislation. Now, this translation is the Court of Justice's official English translation of the case. And what's interesting is in line 2, it says the names referred to in points 1, 2 and 3 of part 3 cannot be used for any other products than those for which. That should have been designations in the English version of the 2013 regulation. And so I rely upon that really for two purposes. One is that clearly the Court of Justice translators thought that the word name there could stand for designation. And secondly, the criticisms made of the Alpro certified translation that we have really don't bear much water, because when you start nitpicking about that, it fails to look at the Alpro decision in a whole. And you see that the Alpro decision does not depend upon small variances in the translation of particular words.
But does that really go very far? Because
no.
If you look at point 2, well, points 1, 2 and 3, no, points 1 and 2 and 3, all these things are names. The real question is whether the names in points 1, 2 and 3 can be used in any way in relation to a product, or just as names for products. Saying, well, this is all about names doesn't really get you home. You've got to show how that works once you get to the first words of point 5.
My Lord is exactly right. My point is much smaller than your Lordship's point. My point is, this is an official translation.
Yeah, oh, sure, I've got
and
that.
they use the term name when translating the Court of Justice's decision with respect to the legislation. The legislation's used a different term.
Yes.
So therefore, nitpicking about whether you use the term name or designation in the Alpro certified translation isn't going to get you anywhere.
No.
So my point's minuscule compared to your point.
Oh, I see.
The Alpro case is not the Court of Justice, but it is the Dutch, not the Dutch, from Holland, yes, it is Dutch. Supreme Court. So it's an appeal from their Court of Appeal. This is a 2019 decision. Now, this case we say bears reading. The unfortunate thing is the numbering is a little bit confusing. If I may take you, please, to page 1078. You can see halfway down it says the assessment of the plea in the principal appeal, the complaints of parts 1 to 3, and then you see the number in 3.11. That is the numbering in the Supreme Court decision. And then can you see under the next heading, the use of the reserved dairy names, it has 3.6.1. That's the numbering from their Court of Appeal decision. If you...
Yes, so because it's within the quotation mark.
That's right, exactly. You'll see why in a moment I'm drawing this to your painful attention, because it gets a bit confusing later on. But if you then turn the page to page 1079, the 3.6.3 is still the Court of Appeal internal numbering, because it's still within the quote. And those two paragraphs, if I might ask you to read those to yourselves eventually, is that they, in essence, summarise what we say seems to be the argument of Dairy UK here. And you can see that particularly in the second paragraph when it talks about any use of the reserved dairy terms is supposed to be bad.
Supposed to be what, sorry? Bad or
Bad.
banned?
It's banned, I think. The prohibition. Sorry, shall I read it in full?
Where are we?
Page 1079.
Yeah.
I'm in the second paragraph under
Part
the heading
argues.
2.6.3,
Yeah.
which is the quote from the Dutch Court of Appeal.
This is the bit that starts the part argues.
Yes.
Yeah.
And this summarises the argument that was put forward in that case, which appears to align with Dairy's case here, namely that any use
It's
of a
the
reserved
any
term
use point.
should be prohibited. And then in the paragraph above that, so the first paragraph under the heading 2.6.3, you can, in essence, get R.
Well, hang on a minute. The quotation marks end just above the part that you're wanting to read.
Yes.
Because
sorry,
the paragraph, the part argues, is really back to 311. It's the commentary of the Supreme Court.
Yes, sorry. But the part above that, in essence, summarises our position. It's the last two sentences. After all, such use is only permitted, after all, such use is only not permitted as a name or as an indication of its soy products if the reserved dairy names are used in any other way by Alpro according to the Court of Justice in Tofu Town. This use is not, as such, and automatically in violation.
So the Court of Appeal is supporting you, and on the face of it, the Supreme Court isn't.
Well, we then get the Supreme Court's finding,
Oh, right.
and this is where the numbering gets a bit more muddled. Page 1082. You'll see a heading 3.2.5, 3.2.6 and 3.2.7.
Yes.
So that's the numbering of the Supreme Court.
Yeah. Where do you want us to start?
Well, I'm afraid you'll need to read all three of those paragraphs at some stage.
Sorry, which?
325 to 327.
Right, thank you.
It all depends.
So, my lords, if I may just highlight parts.
Yes.
On page 1082, under the heading 3.2.5, it's line 4 in my reproduction. It is true that the first paragraph of point 3.5 states that the names referred to are not used for products other than products referred to in those points, but read in conjunction with Article 78, paragraph 2 of the regulation and the other points, it's clear that this concerns the use of the names as designations of the products. The fact that not every use of the names reserved for daily products for other products is excluded under point 3.5 also follows from point 3.6. And then if you jump to the end of that paragraph, it's in essence saying that if you put a wide meaning on part 3.5, then you don't need part 3.6. It would be unnecessary. So that supports an argument that I have, which is that part 6 is the wide, long stop safeguard provision, and it has a proper functionality so long as you don't overstretch point 5. And then the next point that I'd like to draw your attention to expressly is under the heading 3.2.7. And it is actually just as my Lord Stevens has just said, it all depends. The answer to the question whether in a specific case there is use of a reserved dairy name to indicate a non-dairy product as referenced to in point 3.5 undeniably depends on the circumstances of the case. Important whether the name used is part of a more comprehensive statement and how this is structured. And so we say this all supports our position, that this makes it clear that the prohibition with respect to the letters M-I-L-K is not absolute. Rather, it depends upon the context, and we say the context is important here because the use of the letters MILK in the phrase post-milk generation is not as a designation. Now, this case is from the Dutch Supreme Court, so it's not a Court of Justice case, but we still say that the reasoning is valid. The reasoning is entirely independent of any precise translation of any particular term. And that meets the criticisms that have been put forward against the precise translations of this certified translation.
It doesn't go your whole way because it doesn't say, does it, point 5 is only about using one of the designation names as a name.
No, my lord.
It gets quite near it in 3.2.5.
Yes.
But then it sort of wanders off target in 3.2.7 and says
There are two relevant cases. Tofu Town, which is barely relevant, and this, which is more relevant.
Yeah.
That's all I've got.
That's all you've got. Yes. Otherwise, it's pure argument.
But we say the logic of this case, in my view, looks good. My lords, that's really all I wanted to say on ground one. Given that it's only about the meaning of the one word, I've said enough.
Well,
But if there's any outstanding questions on ground one, I should probably deal with them now. No. In which case, if I may, I was going to go to ground two. Now, ground two has, in essence, simplified itself really quite a lot since the permission to appeal application was put forward. And the reason for this is because of the term milk-free. And the way in which, again, I hope not putting forward my learned friend's argument, is that dairy needs, in essence, part of my ground two to succeed. Now, you've seen that there's this proviso to point 5. And the first point is we say the proviso has two parts, separated by and or. The first part is traditional use, and the second part is, in essence, a descriptive use, a characteristic, their characteristic. Now, it appears that dairy support our submission that there are two parts. In the dissenting judgment of Lord Justice Snowden, he says there's two parts, and I'm not going to reproduce those now, but we support his logic on that because it's the same logic we put forward. And very briefly, in Annex 2 to the statement of case, which may be found starting on page 59, we've done a quick analysis of the various languages. And you can see whether the structure between the two parts is separated with an and or, which is the way it occurs in the English, or the word or by itself, which occurs in 4 different translations, and then the Lithuanian is a slightly sui generis construction. Now we say it makes sense that the provision, or the proviso, is split into two because they're talking about two different things. One is traditional usage. This is always a problem with respect to terms in the European Union because the way in which language has evolved in the different countries means that certain things mean different things in different countries. And the second part is the characteristic point. Now, one of the arguments used against us is that the term creamed fruit turns up in the relevant decision. Let me just take you to that, though. there's a decision of 2010, may be found at page 654. Now, this decision relates back to the proviso, and on 655, under Annex 1, you get the English terms that have been held to be permissible and fall within the proviso. So the first one of which is coconut milk. This is permitted because it falls within the traditional use exception. So coconut milk doesn't have milk in it. But if you go to any supermarket, you'll be able to find a can of coconut milk. Yeah. And it's allowed because of traditional use. And then you get things like cream crackers and what have you. Sherry cream, or cream sherry, sorry. Things like that. But one of these terms is creamed coconut and other similar fruit, nut and vegetable products, where the term cream describes the characteristic texture of the product. That entry was used against my submissions in the Court of Appeal because it described a characteristic of the product and therefore fell within the second limb. And we say the reason why it's appropriate for that term to be included within a list of things that fall within traditional usage is because it actually falls within both parts of the limb. Sorry, both parts of the proviso. And so even though it also falls within the second limb of the proviso, it is right to include it in the first limb of the proviso. Lord Justice Snowden deals with that as well.
But this point's gone by the wayside, hasn't it?
Yes, but I still need to, well, it's gone by the wayside in the sense that my learned friend is supporting me. That doesn't mean you're going to find in my favour.
No, I suppose not. Even at Christmas.
So that's why I'm dealing with it very quickly. And that's all I was going to say with it.
Okay.
But then I get to the more contentious bit, is so long as you're with me that the proviso has two limbs, the decision only relates to the first limb, and so therefore the mere fact that something about which we're discussing does not fall within the decision, this is the decision of 2010, doesn't mean that it cannot fall safely within the second limb of the provision. Because milk-free needs that escape hatch. We say that once you've determined that the proviso has two limbs, we say that post-milk generation falls squarely within the second limb. Now, our reasons for that are because in the...
It's presumably common ground it can't possibly fall within limb 1 because there's no traditional usage of the type that accommodates this phrase.
Yes, my lord, it's not common ground in the sense that we've actually agreed it, but I'm not arguing that.
No.
Sure. But there's also, again, in case your lordship's ever asked the question, we've put within the bundle, there's an indication from the Food Safety Authority, non-binding indication that to be a traditional use, it must be used for more than 25 years.
Okay.
In anticipation of a question that hasn't yet arisen, if you see what I mean. But that's the sort of thing we're looking at. I mean, the list is actually quite interesting. I mean, cream of tartar, for example. I mean, it's there because even though it's actually potassium bitartrate, which you might think is not a relevant thing, it turns up in winemaking. It's the white crystals that form on the bottom of the cork of white wine.
Just a matter of interest, how is this sort of list going to be
Right.
maintained after...
May I give you a short answer, my lord?
Probably not relevant to what we need to decide, but it was just puzzling me.
The long and short of it is, the relevant Her Majesty's Government Department goes around and consults food people, saying, what do you think is traditional use? They put forward names. The department looks at it, says yes, no, passes it on to the Commission, who says yes, no.
But I'm asking after Brexit what happens.
I'll come with that. There's a mechanism whereby you can update the list.
Yeah.
After Brexit, there's a similar mechanism, but it's now bifurcated because, you might have noticed this regulation applies to Great Britain, Northern Ireland. Yes. Because Northern Ireland is different with respect to this, because Northern Ireland is still governed by the EU. So you have to do both parts. For Great Britain, you need to do the local bit, by that I mean HMG, going through the relevant department.
Just keeping its own list up to date?
Yes, of which there are no current applications as far as I'm aware.
No, okay.
But for Northern Ireland, you'd need to go through the Commission again.
Yeah.
This is all related.
So you can litigate all over again in Northern Ireland if you want to.
Might I just avoid that question? It's all related to the GIs, geographical indications point, which is all part and parcel of this. Because, as you know, my lord, the GIs are dealt with separately in Northern Ireland from the UK geographical indication point. Does that deal with my Lord Burroughs' point shortly enough? It's not a complete answer, but it's, I think, sufficient for present purposes. My Lords, I was going to take you to, if I may, the very first decision in this case, which is the Patent Office decision. You'll find him behind tab 13, commencing at page 164. And there's two relevant paragraphs here. First is paragraph 21, page 176. This is where the hearing officer Miss Judy Pike has said the exception, this is the proviso that we're talking about, does not apply to the contested mark because A, the mark is not a designation the exact nature of which is clear from traditional usage, and B, the mark does not clearly describe a characteristic quality of the goods.
That wasn't disputed?
No. Before her, this point didn't arise because the principal argument was it was not a designation, and so therefore you didn't need to look at the proviso. But you needed to deal with part 3.6 of whether or not it was still bad. Then the next relevant bit is paragraphs 33 and 34, which commence at page 180. Now, this is under the context of section 33B, which is the deceptiveness allegation. And this is the finding that the mark, post-milk generation, is not deceptive. Starting at line 4, the message is not difficult to receive for a member of the purchasing public that is reasonably well informed and reasonably observant. That terminology is to describe a person, the relevant person for trademark purposes, paying at least an average degree of attention to the purchase. They will not be in such a hurry that they only perceive the word milk, i.e. context, ignore the other two words, and assume that they are buying milk. And then it goes on, the mark does not present actual deceit or a sufficiently serious risk of deception so that the economic behaviour of the average consumer will be affected. Paragraph 34, even if there is no such thing as a post-milk generation, section 33B is not directed at marks containing statements which, although inaccurate, have no bearing on the consumer. There must be actual deceit or a sufficiently serious risk that the consumer will be deceived so that their behaviour is materially affected. The average consumer will not be made to believe that the goods contain dairy milk and therefore be deceived because they do not. So that's a finding of fact at the first instance.
Not under point 6, is it? Or is it not
No.
in terms under point 6? It's actually a trademark issue.
Yes,
Yeah.
that's under section 33B.
Yes.
But it was actually necessary for that finding. Let's put it the other way around. If it had been held that the mark were bad because it offended 33B, it would have offended point 6.
Yeah.
Now, if you then go to the judgment of His Honour Richard Smith, which starts at page 148, there are two relevant paragraphs, first of which is at paragraph 29 on page 158. Relatedly, even if, which the appellant disputes, now the appellant at that stage is Oatly, so me, the mark could be said to represent the designation of products under the regulation. The exact nature of the product will be clear from the consumer's perception of their characteristic qualities as found by the hearing officer, such that the proviso to point 5 would be engaged. Although the perceived characteristic would be the non-association of the relevant products with milk products, and in that sense a characteristic of what the product is not, that is no different from designations such as milk-free, as those two must also be permitted under the proviso to point 5 of the regulation. So you remember that Mr. Justice Richard Smith held in my favour that post-milk generation was not a designation. So this is obiter, but he's saying that if it were a designation, he still would have found in favour of Oatly because it would have fallen within the second limb of the proviso. And we say that this is right for the reasons and the logic that he has put forward. And he's predicating that upon the finding in the IPO. And he's aligning post-milk generation with milk-free. Now, to make it all perfectly clear that he hasn't made a decision on the proviso, paragraph 39 at page 162 says, as such, I also agree with the appellant that the hearing officer construed the prohibition at point 5 too widely so as to encompass the mark. Where she appears to have fallen into error is to assume that the use of the term milk in the marketing of products, or food products at least, constitutes without more the use of the designation for milk within the meaning of the regulation. However, it is the use of the term milk for products to identify them as being milk, not merely its use in their marketing that constitutes their designation as such. In this case, the mark was registered for a variety of goods in different classes, and although it may well have been used in their marketing, it does not purport to market them as any particular product, let alone as milk. Since the mark does not designate those goods as milk, point 5 is not engaged, and no question of the proviso to point 5 arises. Now, in the application for permission to appeal before your lordships, it was wrongly stated, I'm afraid, ashamed to say, that there'd been no finding in the High Court with respect to that.
That error is contained in paragraph 28 of the application for permission to appeal on page 205. So you need to note that when you read that again, there's that error, because the judge at the High Court clearly made those findings in 29 and 39, which we say are all square with our submissions. That, yes, the term post-milk generation alludes to the target audience. And that target audience is a target audience that has moved beyond the consumption of milk. They're the post-milk generation for whatever reason. But as night follows day, if you're marking a product with that mark, with that brand, that speaks to those people, then the only logical conclusion is that those products do not contain milk. Therefore, post-milk generation falls within the second limb of the proviso to part 3.5. It describes a characteristic of the goods. And so therefore, we either win because it's not a designation, or we win because it clearly says it's not milk.
You say clearly is shown by the way in which the average consumer we're told would regard that particular product.
Yeah, as supported by the fact that the High Court judge thought it was as plain as the term milk-free.
Is the test what the average consumer thinks, or is it the test what how the court interprets?
It's the latter, because this is a regulatory matter with respect to regulation the 2013 regulation. The section 33B matter was a trademark matter, and therefore it was all funneled back to the average consumer.
But there's nothing wrong with the court in working out whether the prohibition applies and to work out whether the clearly test is satisfied to put itself in the position of the average consumer, is there?
I would say exactly so, my lord, but strictly it's a slightly different
No, I understand
test.
it's a different...
But the point is this court can still get, we say, some useful guidance from the trademark result. And in any event, that's all I've got. So...
But the Court of Appeal, Lord Justice Snowden is against you on this point.
Yes. So Lord Justice Snowden is with me with respect to there's two parts to the proviso, and Decision 2010 is not a definitive list that encompasses the whole of the proviso.
But then he says
then he's against
it's obviously not clear.
Yeah.
Be his paraphrasing of what he says.
Exactly so, my Lord Boroughs. And we obviously dispute that.
And his reasoning can be found where?
Just one second, my lord. It's towards the end.
Page 144, paragraph 77.
77, yes. Thank you, my lord. 144, yes, exactly. He says they might relate to the age-related characteristic of a particular cohort. And I have to say, I hadn't thought of that. But that was his reasoning. And I'm not quite sure what he actually means, because it could be that you're now old enough that you've been weaned from milk, but I'm not sure. But anyway, it doesn't matter.
I didn't think it only... The concept of having been weaned did seem to me...
I'm speculating, my lord. This wasn't part of the interaction between myself and Lord Justice Snowden, so I don't quite know what he means. Whereas I had a more extensive interaction with Lord Justice Arnold.
You're going to have been weaned before you start to look at these trademarks. Almost so.
One would have thought so.
Now, my Lord, that's basically my two grounds. I win on one or I win on two. I only need to win on one. My learned friend needs to knock me out on both. Are there any points that I haven't yet covered or you'd like me to develop more fully?
Thank you very much.
In which case, my Lord, thank you.
Mr. Moody-Short.
May it please you, my lords. The structure of my submissions are going to follow in general terms those of my written case. There are 5 points I wish to address you on. First, I'll address you briefly, I hope, on the correct approach to interpretation and the relevance of travaux preparatoires and so on. The second point upon which I hope to address you is to address the issue of construction of the word designation. And at that point, I'm going to go to Tofu Town and we'll address all of the points arising from Tofu Town in one go, so we don't need to go back. But construction of designation. Then the third point concerns what we say are the further 2 points of construction that arise. The construction of the other issues within Part 3.5 of the regulation. So that's to do with whether that provision only applies to a designation when it's used alone, so it excludes other words surrounding it. And the learned friend says use of post-milk generation is not use of a designation, and we say it's not limited to use on its own. And the second is the nature and the meaning of the use for prohibition, which my Lord Briggs focused on, which is actually the key point in this whole appeal, which is what is the meaning within Part 3.5 of the prohibition against using a designation, a prohibited designation, for a particular product that isn't a dairy product. So that's my third point. Then I'll address the application of Part 3.5 and the proviso to the mark, so post-milk generation, and I'll address that issue in the light of what went on below. So that's, first of all, looking at the IPO decision and the Court of Appeal decision. And part of that is whether there's any basis for any appeal against those findings. And just to flag up now, although my learned friend showed you 2 paragraphs within the IPO decision that he says amount to a decision, sorry, within the High Court decision, I beg your pardon, that he says amount to a decision as to whether or not the proviso would apply, the first of those was actually just a recital of his submissions. It's not a decision at all. And the second point within that, there is no decision taken. The High Court judge says it doesn't arise, and so he doesn't decide it. So I say there's nothing in the High Court on the scope of the proviso in its application that helps it, but I'll come to that. And then finally, insofar as time allows, and unless you'd like me to engage further, I'll address my learned friend's case insofar as it remains on the external matters relevant to interpretation, so the travaux preparatoires, Article 171. I was going to address ALPRO at that point, but I'll address ALPRO at the relevant point when it comes to construction, because in my submission it doesn't say quite what my learned friend says it says, even if you can understand what it says in light of the problems with the translation. So, those are my 5 points. Before I start, and there's always a danger, having listened to someone's submissions, to add to one's introduction, but before I start, there are 4 points which I'd like to briefly highlight, which are fundamental to the way in which my learned friend advances his appeal, but in respect of which we say he's gone wrong, and also in respect of which it's important I clarify my client's case. So the first point is my learned friend has said on a number of occasions that my client's position is that the use of milk, he says the 4 letters M-I-L-K, the use of milk should be banned in respect of if it's used in relation to any product other than a dairy product. We say that's not quite how we frame our case. First of all, obviously, any prohibition is subject to the proviso. So there is no prohibition in relation to any use of the word milk if it's used in a way that clearly describes a characteristic of a product. Now, on that basis, milk-free is home-free. However one looks at it, it's as clear can be. So, but the second and more nuanced point is what the meaning of the word, it flows from the meaning of use for within that prohibition. It's not my case that absolutely any use of milk falls within Part 3.5. It must be use for the product, which is use that in some way indicates something to do with the product or is in relation to the product. And there may well be uses which don't fall within that. But that is not the bright line point that my learned friend seeks to rely, which is to say that use within Part 3.5 must be use as a designation for his definition of designation. So he says it must
use as a name for.
Use as a name, essentially. But remember, my lord, there are, and we'll look at his constructions, there are, he's got fallback positions, and some of it's name, and he accepts that some of it may be just descriptive use, not a name. I'm not sure whether he's abandoning that, but we'll have a look at the issues as identified in the list of issues as to what his construction is. So
just, can I understand, what's the permissible use of the word milk? You said it wasn't a bright line.
So yes, it's not a bright line, as my learned friend says, that it must
because of the proviso, point one. Okay, what's the second?
The second point is it's not any use at all connected with. It's use. What the part refers to is use for a product, and that, in my submission, is use in relation to use to indicate some thing to do with the product, which could be its origin, could be its name, could be its components, but it's indicating something. It's not merely randomly popped on the packaging in a way that doesn't designate anything or refer to anything or indicate anything. So it's a broad meaning of the word use for, but it's not unlimited, and it doesn't cover all things, and that's entirely in line, we say, with the approach of the Dutch Supreme Court, which was always saying it has to be use that indicates something about the product. So that's very much in line with use in relation to, in a trademark sense, or actually the words used in the provision, which are use for a product. But it doesn't have to be use qua designation, use as a name, or whatever designation.
Can you give us some examples? You said origin. What else would be this broad prohibition?
So it would, if you used as so origin, so as a brand name, or as a, so it would certainly, if you decided to have as a brand name for a food product something that had milk part of it, like post-milk generation, we say that's use for the product. We say if it's
a brand name, it's use as a name.
Sorry, it's used as a particular. It's a use as a name once you've educated the public that it means a particular thing.
But it's still a form of.
It's a form of name. It's a form of name, but it's not name in the sense that my learned friend uses name. Sorry, I've fallen into the trap of adopting my learned friend's approach. But it would also be entirely descriptive use. So, and this is very important because we say the two limbs of point 5, so the prohibition and the proviso, must be construed in a way that the prohibition falls within, that the proviso falls within the prohibition. We say that descriptive use, entirely descriptive use of the nature of the product to show a characteristic of the product, for example, saying something is not milk, non-milk, milk-free, that would be use. That's not a name. That's use to indicate a characteristic of the product.
Well,
that use is excluded by the proviso.
That sounds like use to describe a characteristic quality of the product, so that the argument is then just about whether it's clear or not.
Well, sorry, my lord, I was asked for examples of use.
Yes, I know.
And yes, so on that, so my argument is that use for must necessarily include use to describe a characteristic of a product, because otherwise you wouldn't need the proviso to say, if it's clear, you can do it.
So you say milk-free, no milk, that is designation.
I say that milk-free, for something that is not milk, is use for that. I say that milk is a designation, and its use within milk-free is in fact used as a designation, because it's referring to milk itself, but it's milk-free being applied to the product is use for that product. Sorry, round and round we go in terms of...
But you then accept that it would fall within the proviso?
I certainly accept that milk-free would fall within the proviso, because it's hard to imagine you could be a clearer description of a characteristic of a product that doesn't have milk than to say it doesn't have milk. And there are strong policy requirements, so long as you're clear, for allowing a consumer to be told that there is no milk in a product.
I suppose it depends whether you think of the proviso as a derogation from the prohibition, or possibly for the avoidance of doubt statement that certain things are simply outside the prohibition.
Well, my Lord, in my submission, a proviso of a provision is an exclusion therefrom. It's a derogation. It's not, for the avoidance of doubt, this was never within it. If all you're doing is saying for the avoidance of doubt, then the proviso would be entirely otiose. And it would be peculiar indeed. And I'll come on to it. So milk-free is a useful test in my opening comment. So we'll come on to look at it. Because it's instructive to consider the basis on which, on my learned friend's case and my case, the term milk-free is free for use. Because that we agree that it should be free for use. Sorry, I shouldn't use free for use. It's available for use. We agree it should be available for use, but the basis on which we do it reveals fundamental points about our submissions. So, on my construction of designation and the term to designate, and on issue, when looking at that part, point 5 of part 3, that use for extends to use of words that refer to a product in a way that indicates something about it, including as all or part of a trademark. And that's what the Court of Appeal say. I can show you that issue. It's probably worth just bearing in mind the parties' stated constructions. Within the core bundle at tab 2, page 12 of the electronic bundle, we have the agreed list of issues. And under 8, the issues to be determined by you, my lords. Issue 1A, what is the proper construction of the term designation? My construction, does the term designation extend to the use of words or phrases that refer to the product in any way, including as all or part of a trademark? That's how I advance it. And on that basis, the use of milk-free for a non-milk product would amount to use of the designation milk as part of that composite descriptive term, would fall within the prohibition in the first paragraph of point 5 within part 3. And I don't know whether it's worth, it's graven on my heart, but I'm happy to show it to you so you bear the words in mind. It's split into 2 paragraphs. Is it worth looking at the provision in question? This is at page 484 of the bundle.
Yes.
And at this stage, I should just flag one point, that some of these provisions appear twice within the bundle, so some of my references will be different to the ones that my learned friend has used. I tried to harmonise them But
Well, if it's any comfort, Mr. Moody, we have a little paper crib sheet which has got the key words printed out on it. We don't have to worry ourselves which page of the bundle it appears in.
well, I'm obliged. That's a very great relief. Point 5 says the designations referred to in point 1, 2, and 3 may not be used for any product other than those referred to in that point. And so we say milk-free for a non-milk product would amount to use of the designation milk for that non-milk product. It's not the name of it, but it is descriptive use. But that is then saved by the proviso, which, and the second limb of it, because there are two limbs. The first limb, this provision shall not apply, and so there it is a derogation, to the designation of products the exact nature of which is clear from traditional use, those are the ones on the list, and or when the designations are clearly used to describe a characteristic quality of the product. So we say milk-free, saved by the second limb of the proviso.
This provision shall not apply could mean this provision is simply not about, or it could mean the prohibition in this provision shall not apply, even though the activity in question comes within the provision.
My Lord, I have to accept that that's a possibility. My Lord, I urge on you the...
I don't think it is the latter.
Yeah.
But the latter would make the proviso a derogation, whereas the former would simply be, for the avoidance of doubt, this provision simply isn't about this sort of use.
Well, my Lord, in my submission, the second limb so the proviso in the second paragraph under 5, on whatever basis it's within there, is useful when considering the breadth of the first limb, because if it weren't for the fact that descriptive use, which is the second part of the designation, would otherwise be thought to fall within the first part of the limb, there would be no point in saying it. So it's a useful, so I rely on that in support of my construction of useful in the first limb. And I'll come on to whether, when we look at it, you see, the other peculiarity of this is that the decision of the Court of Appeal, insofar that, well, the views expressed by the majority of the Court of Appeal in relation to that Commission decision list were, strictly speaking, obiter, because every single member of the panel in the Court of Appeal held that post-milk generation did not clearly describe a characteristic of the product, and so the question as to whether or not the proviso was available was not decided because they didn't fall within it in any event. Now, on my learned friend's constructions, and bear in mind those two constructions are either that, first one is the term designation to be given the same meaning as it was in the previous regulation, and as I'll be submitting, that's quite wrong when one looks at the changes between those two regulations and the adjustments that are made. But that's his first construction, so that would mean it is the name used at all, designation means the name used at all stages of marketing. And then his fallback, issue 1A2, is the term designation limited to words or phrases when considered as a whole, that when considered as a whole, are solely descriptive of, so either they are descriptive, solely descriptive of, or are generic terms for the goods that they designate. So the generic terms for the goods they designate, that's, I think, what he calls a name, but he accepts that on that construction, solely descriptive, without being a name, would be something that's what he's advancing. And then the final part of issue 1A, subparagraph 2, is that it starts, and or does the term designation exclude any properly registrable trademark, as the appellant contends. That final point is no longer advanced by my learned friend. There was and that's important, there was a sort of registered trademark get-out-of-jail-free card that he was relied on in the Court of Appeal, and that he's not advancing that anymore. And we say that's actually very important on this case, because absent an exclusion for trademarks, the operation of the proviso means we win in any event on the facts as found. So, on those constructions, on the learned friend's primary case, the term milk-free, he says, is excluded from operation of Part 3.5 because it is not the name used at all stages for marketing the product. So he says that the term milk-free, even though it contains this, as clear can be, this particular protected word, is removed from the scope of the regulation entirely, the regulation that's addressing the use of the term milk, merely because it's not being used as a sales name. We say that is an extreme position, and it's not mandated, as I'll come on to by the materials and on the construction, or indeed it's inconsistent with the authority. Then on his secondary case, he says that milk-free, I think, milk-free would fall within the prohibition under paragraph 3.5, because although it's not the generic term for the product, on his construction, it is solely descriptive of the product. Yeah? Milk-free is solely descriptive of the product. And so that would then fall within, but it would then be excluded by the proviso, which we say is that accords with our position, and that would work. So note that on his construction, just before we get into it, his construction that terms must be solely descriptive, that would have the effect that the addition of a non-descriptive element, such as a brand, would exclude the use of a designation from paragraph 0.5, paragraph 3.5, part 3.5. So if it has to be solely descriptive, then although you couldn't use milk to refer to a non-milk product, if you called it Oatly milk, and you say, here's my composite mark, Oatly milk, that would be something that on that construction, if it must be solely descriptive, wouldn't even fall within 3.5. And we say that's a startling submission. That's why it's solely descriptive, we say cannot be right. And indeed, when you look at the Court of Justice's decision in Tofu Town, they refer as designations to matters that have brand significance. So I think there's soya to tofu or something is referred to. And so it doesn't have to be solely descriptive. We say that limb of his construction is inconsistent with authority. But we can see that on either my learned friend's case or my case, milk-free is available for use in a descriptive sense. And so it's a complete straw man to say that unless his appeal succeeds, milk-free cannot be used. So, the third point, and I realise I'm going through, there are 4 introduction points, but the third point, before I get on to my substantive points, is my learned friend's contention that the use of the mark milk-free generation in relation to non-dairy products would have been lawful under the definition of designation under the 2007 regulation. That is to say, if designation means the name used at all stages of marketing, certainly in his written submissions, though he hasn't majored on it today, he has said that milk-free generation would have been lawful under the old...
Post-milk.
Sorry, post-milk. Post-milk generation, sorry, I don't know. We say that's not so. So if you turn up the 2007 regulation, I'll just explain our case as to why post-milk generation would have been prohibited even under the old regulation. So page 645 is where I've got the version I've been...
Does the annex to the appellant statement of case contain it in full?
We can...
Possibly not safely in any way in lurid colours.
It could be. It has the definition within it. I think my lord, if I can do it by reference to the...
Well, no, I don't want to take you out of your course.
Once one loses track...
I think it was just a lazy shortcut.
Well, I'm all for lazy shortcuts.
Which paragraph of the 2007 regulation are you wanting us to look at?
So at page 645, we see the setup. So this is the annex. This is Annex 12. And you see the definitions. So for the purposes of this annex, and this annex only, there's a definition given both of marketing and of designation. And so designation means, and it says designation means the name used at all stages of marketing. And then at point 2, lower in the page, you see for the purposes of this annex, milk products means, etc. And then you see the following shall be reserved exclusively for milk products, the following designations. I'll just flag up that's a word that's changed in the revised version, but then the list of designations that are dealt with. And then at 3, you've got the composite products, and then at part 3 on the next page, use of designations in respect of competing products. And what's said is the designations referred to in point 2 of this annex may not be used for, so same wording, used for any product other than those referred to in that point. However, this product shall not apply to the designation of products, and again, it's the same words. Now, on my construction of 3.1, consistent with my construction of point 5 in the 2013 regulation, use of designation for a product is not limited to use as the name of a product and is not limited to use on its own. So post-milk generation, under the 2007 regulation, we say would have fallen within the first limb of 3.1, so the prohibition, and for the same reasons as it doesn't fall within the proviso, it would not have been saved. So we say, and this is really it highlights my Lord Briggs's point, that the meaning of the word designation really isn't the key here. It's about what use for relates to.
Even though at that point we indisputably have to read designation as meaning name.
Yes.
So the name referred to, so I'm just transposing, the name referred to in point 2 of the annex may not be used for any product other than those referred to in that point.
Yes.
So the name would be what?
So the name, milk is a designation on anyone's thing. So the milk, so the designation within that is, so we can say the term milk, because that is one of the designations referred to, may not be used. So milk may not be used for any product other than that referred to. And again, this is part of it. It's used for does not require it to be used as a designation. It's broader than that. So we say that under
your point is that if the real issue of construction is what used for means, the words are identical in both regulations.
My Lord, yes. And indeed, so when my learned friend says you'd highlight a change if there were a change, if there was a significant shift in the legislation, none of this applies if use for is the same in both places. What you've done is shift a definition of designation, meaning one thing, to another. And then, final point, which is actually, I probably don't need to go in any great detail, is that, my lords know that the final point which follows on from that is that it's our case that post-milk generation falls within the prohibition on any meaning of the term designation advanced by my learned friend on this appeal. And we say that because milk is not clearly used to describe a characteristic product property of the product as part of his mark, it's not saved by the proviso, whether under the 2007 regulation or under the 2013 regulation. And indeed, in this regard, it's worth looking at paragraph 51 of Lord Justice Arnold's decision, where he, in my submission, rightly points out that my learned friend is approaching this question from the wrong way round. So, paragraph 51 of the Court of Appeal decision, behind tab 10, it's page 138. So here, this is a passage where Lord Justice Arnold is setting out his reasons why he doesn't accept my learned friend's construction designation. But at 51, he says this: lastly, Oatly's argument proceeds from the wrong starting point. This is meaning of designation and so on. Oatly argues that the trademark must, as is conventional for the purposes of trademark law, be viewed as a whole, and that considered as a whole, it is not a designation, because it is a trademark. In my view, the hearing officer was correct to start with the fact that milk is a designation referred to in point 1 of Annex 7, Part 3. By virtue of point 5, it therefore cannot be used in relation to any product which is not milk, as defined in point 1, except as permitted by point 3, which is not relied upon, or the proviso to point 5. It is common ground that the goods in issue fall within the scope of the 2013 regulation. That's because they're food goods. T-shirts are outside the scope, but are not milk, as defined in point 1. As Tofu Town confirms, it's immaterial that the trademark contains 2 other qualifying words. For the reasons explained above, it's also immaterial that it is registered as a trademark for the goods in question. We say it's important to focus on the fact that the point 5 regulates the use of the designation, but it's not just the use of a designation on its own, it's also use of a designation within the broader mark. So it's not limited. You don't get out of jail by putting something in front or behind it. And on that basis, focusing in on milk and then saying, does this clearly describe, we're led irresistibly in my submission to the position that my learned friend's trademark falls within the first limb of point 5, and then the question is whether it is then excluded from that or saved by virtue of the proviso. And we say not so. And that it was previously said by my learned friend that a trademark would suffice.
I mean, it could be said that paragraph 51 of Lord Justice Arnold's judgment slightly begs the question, because he's interpreting for as meaning in relation to, which is maybe a rather wide interpretation of for.
My lord, yes, but well, it's...
He's not on that point at that stage, but he is clearly of a mindset that says use for has a very wide meaning.
My lord, yes, and that, in my submission, it's, in my submission, the correct construction of that use for, what it means, is fundamental to the point. That's actually the issue, rather than where my learned friend is focused on the issue of designation. That's actually the heart of it. That's actually the heart of it. So, those were, I'm sorry, they took a while to go through, but I thought it was important to get my points out there so you have the shape of my submissions. Those are my introductory remarks. I am hope that in the time before rising for lunch, I can address you very briefly on the correct approach to interpretation. Now, in our written submissions, there appeared to be a difference between the parties which may not have any application, particularly, as to the basis on which the Supreme Court should approach the interpretation of assimilated law post-IP completion day, in particular when the law has not been changed. It's common ground that your lordship is not bound by any approach to construction under EU law. But my learned friend contended in his written note that the approach to construction under EU authority was persuasive and you should be guided in that way. In my submission, and again, I'm not quite clear how relevant this is now, the correct approach to interpretation of assimilated law is the same as any other domestic legislation, but when considering the objective purpose of the legislation now, one must bear in mind the purpose of the EU provision that was the parent of it, and so for that purpose it's fundamental, it's common ground, to consider the recitals of a regulation or a directive that was the parent of an assimilated law provision. So it may be a matter of philosophy rather than anything else, or certainly not applicable, particularly important in this case, but the well-established principles of construction set out in the well-known passage from Lord Hodge in Crown against Secretary of State for Home Department emphasises the importance for context, looking at context and at considering the objective purpose. And we say for EU legislation, that objective purpose is often found and light is shed on it by the recitals of that particular provision, not, as my Lord raised earlier, not earlier provisions. We say look at the recitals of the present one. And the only other point, which was of some, again, I'm not sure whether there's a dispute between the parties on this, is that when it comes to looking beyond the recitals, when it comes to looking at other travaux preparatoires or background materials, in my submission, the correct approach remains, whatever the position under EU law, remains in this jurisdiction that, as Lord Justice Jacob put it, only a bullseye counts. One has to, in order for travaux preparatoires, in order for proposed amendments that were then rejected, irrelevant, it's got to be a bullseye.
Was Mr. Jacob talking about EU travaux or parliamentary travaux?
Well, I'm talking about EU. Well, for these purposes,
I'm just trying to remember what Lord Justice Jacob was talking about.
He was talking about parliamentary.
Right. Okay.
But they were broader actually. He was because I think it was Counsel for, well, it was Martin Howard. There were references to TRIPS and various other. There were some very broad materials that had been canvassed in Nova and Mazuma as to the meaning of certain terms in copyright legislation.
Yes, if one looks in European legislation to the recitals to ascertain the purpose of the legislation, whether one approaches it in your way or Mr. Edinburgh's way, is there really anything material in this case?
My Lord, in this case, the conclusion I've reached is probably no.
No.
As a matter, I'm not ruling it out as a point, but when one sees an approach to construction set out in the other side's case, and you think, well, either I say I agree, or you say, well, I don't.
No.
And so that's
fine. But so there is a philosophical difference, but whichever we might plumb for may not affect the outcome at all.
My Lord, I think that's probably right, and I think I've got to the stage where I can move on to construction. I want to do a little faster. I'm even before lunchtime. So, the first point I was going to, just much as I'd like to rise for lunch, having just been called a philosopher, I'm not going to bank that. I'll move on.
You've got your 4 minutes to outline your position on construction.
Well, much better than what Lord Sumption used to do at the bar. Perhaps your Lordships would like to take that away and think about it over lunch.
My Lord, if I'd given you anything particularly useful to think about, I'd be joyous in adopting that. What I can do is dispatch very quickly the starting point, which we say is, when considering the construction of designation, a useful starting point is the normal English meaning of designation, which is not limited to a name. It encompasses a name, a descriptive name, a word, a descriptive phrase, and it also, and this is something that does feed in when we come to consider how matters are set out, a designation when something is said to designate, we'll see in the provisions that so-and-so designates X, Y, or Z, we say that reflects usefully on what a designation means. And so when designate is used, as we'll see when we come back after lunch, to refer to entirely descriptive terms that are not names, then we say that's a strong indication that designation is not limited to names, because you can't designate something that isn't a designation. The two are two sides of the same coin. So, my lords, I think I may have batted out my 4 minutes before lunch. And so, if you'd like to take that way and think about it.
You've batted 2 or 4, but if you're wishing to start a new chapter after lunch, then that will be a convenient place to adjourn.
I'm obliged.